Today we are going to be going through 3 ways to know when it's time to update your estate plan without it being too late. And I really packed in some extra content for you today, and I'm going to save some time for us to go through some Q&As for you. And what you're going to leave with at the end of this webinar is some actionable steps that you each need to be doing each year to put the planning back into an estate plan, right? And so that's a really super important part of what you've done to make sure that these estate plans are working for you as intended. So what we're going to be discovering today is how to spot events that will erode your desired legacy. And this is really important because you each came to me with objectives, right? You each came to me looking to plan to protect your families, protect assets, make it easy for assets to pass to your beneficiaries, your children, your spouse when you passed away. Now, there are things that are outside of your control that can change how that works. Remember, the estate plans that we put in place ultimately get reduced. All that time that we spent, all that planning gets reduced to ink and paper. It becomes almost static. So it's not the plan that becomes really important, it's the planning process. The real valuable piece of what we did together, each and every one of you, and each person here on this webinar is a client. I've restricted this just to people that I have helped personally for this reason. We're going to be showing you what key life events you need to be looking out for and changes in your circumstances that you can easily spot that will raise flags for you to know exactly when you need to say, this is time to make an update here. We're going to be showing you some increasing and decreasing values and assets you need to be looking for, or how when you acquire new assets, changes in what you have and how that will affect the plans that you've put in place to make sure that they avoid probate, that the assets that are put in there, your trust, if you've done it for tax reasons or for Medicaid planning purposes, that they actually do accomplish those goals. We'll also talk about legal changes. They're often in the realm of tax laws as well as Medicaid laws that change, right? And so we need to be proactive about knowing those changes and taking advantage of the opportunities that they create for you. Also, if we were planning on being a little bit more reactive in our approach because of things that we thought we could rely on, those things change. Just in the last 6 months, we've seen significant changes in tax laws with the Secure Act that passed in late December. And we've also seen significant changes in the community Medicaid program here in New York and how we can plan for that. So we might need to be looking at our plans, not only for those changes, but the changes that occur on a yearly basis. Now, this is for you if, well, one, you're a client of mine, right? So you've already taken that step. You've taken the first big step in terms of putting together an estate plan, taking the time, taking the process seriously, sitting down and putting together a plan, because you've obviously thought it was very important to prioritize planning for your family's future, to not leave a mess behind. But this is really for you, and I know why each one of you are here, right, is because you're frustrated about not knowing exactly what to be doing next, right? We did this, now what, right? Now what do we do to make sure that this continues to work? You're worried about increasing long-term care costs and taxes. So long-term care costs are the home health aides and nursing homes that we talked about, and those are ever increasing every single year. And many of you came to me to help say, how do we protect our assets, secure the care we need, and leave as much behind for our families? The costs of doing so are changing. They're increasing at an astronomical rate, as well as the opportunities that you have to plan are changing as well. Taxes are increasing and decreasing. Right now, for example, they're on a little bit of a lower side, but they're automatically going to go back up in about 6 years, which gives us some opportunities to be able to do things. Now, those might go back quicker, and we need to be aware of those legal changes. This is also for you if you want to protect the investment that you made in your estate plan, because you have done the effort, put the time in place, spent the time and the money and the resources to be able to put your plan in place. But now you want to be able to make sure that you have actionable steps, knowing what your homework is to be doing each year to make sure that that's not just a waste. And you don't want to leave a mess behind. I'm curious, many of you came to me and you had an estate plan. If anybody's done an estate plan before they hired our firm, can you just do me a favor and put a Y into the chat box? Did anybody do an estate plan? Betty, thank you. Yeah, so Betty had done an estate plan beforehand. Anybody else had done an estate plan before they ever came to my office? Fantastic, Joe. Yeah, same thing with you. I know that as well. And guys, thank you so much for participating. Usually I'd have you in person. I'd be asking you these questions. You'd be raising your hand. I like to have an active, ongoing dialogue with everybody. So I really appreciate you just jumping in and putting things in the chat. Anybody else? Anybody else had an estate plan before they came to me? Great, thank you, thank you. Yeah, so another, so and for many of you, it was many years since you had prepared your previous estate plan. Sometimes 10, 15, 20. Our kids were young, right? Our kids were we maybe just had kids, right? Maybe we just bought a house, right? And thank you, Joe. Thanks for liking the wall here. So here's the thing. I would love to hear if everybody who has done an estate plan before, tell me why they didn't go back to the attorney, for example, that prepared their estate plan the first time. Can anybody share with us why they had, well, share with me rather, why they had, it's all anonymous to everybody else. Just to me, I get to see your responses. But share with why they didn't go back to the attorney that prepared it the first time. Well, for many of you, the reason is, and you've told me, is that look, it was a basic plan. It was just the bare bones essentials. There was no planning. They just sold me a piece of paper. I never heard from the guy again. I haven't touched this thing in 20 years. I wouldn't even know where to find the person. And that's really the mess that we've put in place, that you came in with. And we put a plan in place. And what I don't want to have happen to any of you is to have that happen again to you. Now that we've done this, let's make this plan. So maybe when the updates need to get done, there's small tweaks that need to get done to keep up to date rather than complete revampings of your estate plan. And rather than doing it, checking it off the list as something that's now done, that we engage in the planning process. So imagine if you could wave a magic wand and we could picture your ideal future and what your estate planning process will look like moving forward. It would be that you'd be making proactive moves to be protecting your money and ensuring your wishes are kept. It wouldn't be about being reactive. It wouldn't be about waking up in a sweat in the middle of the night saying, geez, we really need to get down, update that plan. I have been putting it off for 2 years. Oh, my agent has passed away. I know I need to get down there, but I just haven't done it. You would be making proactive moves to protect your money. You'd be saying, wow, there was a legal change that happened in 2019 that changed how IRAs are inherited. What opportunities does that give us to plan ahead for the income tax consequences so we can actually save money for our family? In this ideal future, you'd be saying, slides to advance here, you would know that every year, because you're constantly looking at everything like you do with a financial plan, that all the loose ends are continuously being tied up. And you could also, if you chose to, have a true advisor in your corner year after year helping you do that. Now, more about me for a second. I'm going to make this about me for a second. Now, I just wanted to remind you, just it's been some time since we spoke, of who I am, right? And so you all know me. I've represented you. I'm your attorney, but we've spoken about it before, and I just want to remind you what my inspiration is behind our practice and the strategic goal that we have to bring to people, right? So I didn't grow up in an attorney family. I grew up the son of a hardworking carpenter, a stay-at-home mother. I didn't have a whole lineage of a firm to grow. I didn't have any desire or dream to be an attorney. I actually didn't even know what I wanted to be an attorney until I accidentally became an attorney. No, I shouldn't say that, right? What happened was I just was a regular kid, but my dad taught me very early on to work smart, not work hard. He was a carpenter. He was a very hard worker, but he said, Jay, you need to work with your mind. You need to work smart. And I took that into saying, I need to get my education. And when I started to do that, I saw how complicated laws are. And now laws are the rules of the society that we belong in. And if we don't know the rules, how can we really actively participate and take care of ourselves and take care of our families? So when I started studying law, and I did it as I was trying to become a police officer, I studied criminal law, was my first law class, and I wasn't a fan. But once I started working in an estate planning law firm, I saw this dealt with finances. This is your ability to protect generational wealth for your family. It starts small and it rolls like a snowball, but knowing how to plan ahead was very important, and it is complicated. So I started working in law firms when I was about 20 years old. And I did so because I felt that law school was a big commitment, both financially and time-wise, and that I wanted to actually see what a law firm worked, how it worked, and what it looked like. And I worked in a number of different law firms throughout my undergraduate career and my law school career. Now, what I found in most of these law firms is that law practices suck. The attorneys suck. They talk down to people. They think they know what the person wants, needs, desires. They don't listen. They don't return calls. They feel that they're some sort of noble profession, right? Which is, I don't mean to put down their wishes, but in terms of the firm that I wanted to build, that I thought this sucks. It's not about the client. It's about the firm and about the revenues. Sure, it's a business, but you get there by helping people. And by helping people, that's how we get more business. And that's how we continue to be able to reach out to additional people. And I didn't see that in any of the firms that I worked for. I also saw that most of the firms were developing now from an hourly practice of billing, which sucks. You all know that, right? So yeah, call me up and I'll bill you for 35 minutes for a phone call, right? And it was a 6-minute phone call. But they started moving to flat fees, and they started saying, well, here, I'll do your estate plan for a flat fee, and like we did, right? And so, but what would happen is they wouldn't engage the client afterwards. Why? Because you walk out the door, it's a transaction, right? It's a transaction. You purchase the estate plan, it's done. I didn't like seeing that. I understand the shift because that's what the market was demanding. But what happens is then your estate plan, your matter becomes transactional. And this area of practice, it's anything but transactional. This is not a lawsuit, right? This is an active, ongoing planning. And I also found that most of the law firms were old. They were just old, man, like old with like lots of books. And if you've been to my office, I have my fake books there, right? I told you I've never read them. They're only there for looks, right? I should just throw them out. They don't use technology. They refuse to email. They're not using ways to be able to innovate how you interact with your law firm and how you can be able to access your needs. So why does that matter to you? And it's because each one of you chose to hire me, right? You know why that matters to you. You've chosen an estate planning firm, a firm that was dedicated to just providing elder law and estate planning services to our clients in the best way possible, going an inch wide and a mile deep in this one area to be able to help you. And doing that in an innovative way that is client-centered and providing you with the best service possible. Now, why do I do what I do? I do this because these people right here. This is my family. This is us last Friday. We went out to dinner to celebrate my oldest, Eliana. She's there in the center. She just graduated from pre-K, already on her way. I couldn't believe it. So we went out and it was a great, beautiful night. It was the first Friday night rather, being reopened down with the restaurants being able to do outdoor seating. And so we went out for this beautiful dinner. This is why I get up every day and I do what I do. I spend long hours finding different ways to be able to provide the value to you, as well as looking and keeping up to date on new and creative planning mechanisms. So that's Eliana in the center. Lily, that's her little sister. She's right behind her. She'll be starting at the pre-K starting in the fall as well. And that's my wife, Brigitte, off to the left, taking the selfie for us here. But that's why I do what I do. But why am I so passionate in what I do? And the reason we're so passionate is because people need help. These rules are complicated. By not taking advantage of the rules, you're leaving things up to chance. And there's just as many people who are taking that step and becoming educated or surrounding themselves with advisors so that can help them. The laws are complicated. They change often. They have different rules for Medicaid planning, tax planning, income taxes versus estate taxes, probate laws versus trust laws, right? But without conscious action, things are left to chance. And this is where we decide to put the planning into the plan, where you can have a checklist of things that you need to be doing every year to make sure your estate plan is working. Because without the conscious action, is you're leaving it up to the roll of the dice, right? Whatever the outside circumstances might be, dictate what happens to me. But most importantly, I have met with each and every one of you personally, a little different than staring at this camera today to see you, but I've met with each one of you personally. I've seen how transformative this process has been. I've seen each one of you come into my office overwhelmed, not knowing your options, concerned about what the future might hold, and not knowing what we can protect for our family, going through a meeting, preparing a plan, reviewing that plan with you, putting that plan into action, whether it be a year ago, 2 years ago, some of you 3 years ago at this point. But seeing that sense of relief that you've had after leaving from that final appointment, and seeing how you are have a peace of mind, right? And how you are secure now, knowing that you've taken this conscious action to protect your family. I truly get pleasure. My team gets pleasure out of seeing that. And I hope that maybe some of you have seen some of them. We've grown significantly for some of you who have plans that are a couple of years old. But we have each seen that, and they come each day to be able to do that. Now, let's make sure we have our pen. Let's make sure we have our paper. We're going to get into it. If there's one thing I want you to take away from this webinar, I want you to know that your estate plan is not set it and forget it. Okay, sure, you put it in place, and the next day it's probably going to work. But every day that goes by, there are changes that happen in your lifetimes, and there are changes that happen to the tax laws and to the Medicaid laws, which we'll talk about a few important ones later on in this webinar, that affect how your plan works. The plan is the final action that you have reduced everything to from the planning process of figuring out how to best accomplish your goals. So once you get that in place, you don't need to review it every day, but there should be things that need to get done in order to make sure that the objectives that you have, the goals, the wishes, the legacy that you desire are actually accomplished by the plan. Sometimes if there's a huge radical change in the law, which is not all that common, then it requires a whole revamp of your estate plan. Sometimes it's just a matter of tweaking things because maybe I had a successor healthcare agent that can no longer serve anymore, and I don't want to run the risk of having no agent in place. Or maybe I had second thoughts about who my agent should be as I've aged or grown or thought about this some more. These are things that need to be addressed. Now, there's 3 things that you're going to discover in this today. It's not the only 3 things that you need to do, but what I did was curate in a manageable content, right? So we're not here forever. That 3 major things that you need to be doing each year. So the first thing you're going to discover is how to keep your trust properly funded. Many of you have trusts that we've prepared for you, and the trusts are only as good as what you put in them. So we'll talk about that. The secret to keeping your asset protection plan working, that's the second thing we'll talk about. There are key life changes that are happening in your lifetimes that you need to address and review. And you have to be reviewing asset changes and values to make sure that you are taking the opportunity to protect as much money in the most efficient way possible for your families. That's been many of your stated goals, making it efficient, not leaving a mess behind, and protecting as much as possible of our hard-earned money for our family. The third thing we'll talk about is what the government doesn't want you to know about changing Medicaid and tax laws. We'll talk about 2 major changes that have happened in the last year or so. But the major thing is that the government doesn't want you to know about it because it doesn't make the headlines. They bury this stuff in budget bills that are 800 pages long. And you have people like myself that know that they do this and go and look through there. And I go and search and line item by line item, look for the things that affect my clients. And that's because it doesn't make the major headlines. It doesn't say, great changes are coming your way. Hey, client, go ahead and update your estate plan, right? They don't do that for you. All right, so let's go into number 1. If everybody has their paper and pen ready, this is where you can start jotting down some notes. The first thing we're going to talk about is how to keep your trust properly funded. This is really important, super important. That's why I have put it as number 1. If you do not do this, you will have a delay in getting money to your family. As a reminder, we talked about the differences between probate and trust, right? Wills and trusts and how that process happened. The things that you put in a trust will avoid probate. But if you don't put things in the trust, then what happens? They will have to go through probate. The probate process takes about 12 to 18 months often in cases. Right now, it's actually taking longer. I have many clients that couldn't file a probate proceeding because the courts were closed. So if they were reliant on a will or they had a trust but was underfunded, then what would happen is that they wouldn't be able to get access to their assets. Well, the family wouldn't be able to get access to the assets. And now we're waiting 12, 18 months. I have one client where we're still waiting 3 years to get the access to the estate in Queens County because they didn't actually have a will whatsoever and no trust. And so we're in this big bulk of the 70% of people who don't take this action like you are, being proactive. And it would spend 3 years waiting to get access to this. If you don't keep your trust properly funded, it will reduce the amount of money that you can protect for your loved ones. trusts, right? So many of you are putting together a trust for asset protection purposes. And for many of you, that's long-term care. And we talked about putting assets into trust, starting look-back clocks, right? The longer we wait, the less that we put into the trust, the more that's outside of the trust, the more that could be subject to a clawback or liens or recovery by the state where it wasn't necessary at all. The same thing goes for taxes. Their example in New York, if we have a taxable estate, there is a 3-year look-back period for assets that will be clawed back in that you've gifted away. So that becomes an issue, right? So if we wait and we don't properly fund the trust, then the amount of money that we can protect for our family gets minimized. It'll also increase your probate costs. So that goes back to that time expense of probate, but also probate costs money. I mean, you have to hire an attorney, you have filing fees, you have court hearings, process servers, even if it's uncontested, there's all this ongoing expense that you have to do through probate, which can be avoided through the trust, which is a very, very, very important benefit that we've all talked about. So just a story, this is not just for you, this happens to everybody, right? So Michael Jackson, this is an interesting story, worth millions of dollars, right? Creates a revocable trust. The revocable trust, the main purpose of it, as we've talked about, is to avoid probate, to avoid the need to have your executor go to court to be able to get assets for your family, that it can automatically go. But remember, the trust only governs what you put inside of it. So if you never put anything inside of it, it doesn't do anything. Michael Jackson was sitting on an unfunded trust. He had this revocable trust in place, but didn't put anything inside of it. He died with his assets in his sole name. Now, that resulted in $200 million in estate taxes and years of court battles between the family, not just over the money, but on who should be the executor, which will was valid, this last will wasn't valid. The thing you have to remember, if there's one thing I want you to take away from this story, is that underfunded and unfunded trusts don't avoid probate, okay? So this isn't just something for the rich and famous, right? We know that, that's why you came into my office. But the issues are just dialed up to the 100th degree, right? Because of the size of the estates. But all the issues are there. The underlying issues of making sure that we title the assets into the trust, making sure that we've addressed family issues, we've addressed every possible scenario that we can to make as little stress as possible for our family members in a stressful situation that would create a family fight. Right, so we dial that back a little bit. I don't know about you, but I don't have my estate that will render me $200 million in estate taxes. But the key component is that the trust wasn't funded. So what do you need to do then to make sure that your trust is funded? The first thing that I would recommend that you do every single year is review an asset sheet. Each one of you should have a balance sheet. You should know exactly what your assets are and how they're titled. It's often that we have clients that we have put trusts in place for that either change the title of an account after we've helped them, they've acquired a new account, but they don't put it into the name of the trust. And if they don't put it into the name of the trust, then it's not part of the trust, okay? So this often happens with a new account that you've acquired. I mean, if you remember what we did when we first helped you was usually putting a piece of real estate into your trust. That was the one we usually helped you with, and you left saying, well, I'm gonna review as time goes on, I'll put other assets in. But maybe you've gotten a new account. If each one of your trusts that we've prepared for you have a section in it that tell you exactly how to title the trust. It's in section 1, right in the beginning of the trust, so you can see exactly how to title it into the trust. But let's say you opened up a new brokerage account and you put some stocks in there. You need to make sure that that account is titled in the name of the trust. It's often the trustee's name as trustee for the name of your trust. And that's all there in section 1s of your trust. But you'll get there by making sure that each year that you review that asset sheet. So you just prepare an asset sheet, see what the title is, jot it down. This will also help you, so not only just for your own purposes, but if you were to become incapacitated and your power of attorney needs to get access and know exactly what you have. And if you pass away, it'll give a step up also to your executor and your trustee, knowing where the assets are and how they're titled. But most importantly, it'll help you make sure that everything that you want to be in the trust is there. When you acquire new assets, you'll title it just the way that your trust says to do that, whether that be a new piece of real estate, a new bank account, because if you don't, what will happen is they'll pass outside the trust. It's really then also important that you value your assets often. So this could be really easy for a cash account, right? You go down that asset sheet we talked about that you're preparing, and you're going to go ahead and list the value of the account. And that's easy because you can just go on your online statement, right? Or your physical statement and see that. When it comes to other assets, the larger it is, the harder it becomes, and actually more important it becomes to value. For example, real estate is important to value, but that's not that difficult. It costs a couple $100 to get an appraisal, but then we know the value of our estate. And why is that important? Because Medicaid protection and tax planning are based off of values, right? So often when we are first getting your plan in place, you're scratching out a value that you are putting upon that. Now, I'm not going to lie to you. I'm not I'm not a licensed appraiser. You're not a licensed appraiser. I can't value those things. You can't accurately value those things. So we're making somewhat uneducated decisions. And the best information that you can put into your plan is best. Now, if you have business interests, those become even more important. So business interests become valued by business appraisers, not even real estate appraisers, but by business appraisers. And they're complicated formulas about future earnings and minority discounts. And that all becomes very important for how do we want to divide things up to our family, but also making sure that we've planned to avoid any estate taxes or Medicaid taxes. All right, moving on to the second topic that we'll talk about today. Now that we know how to keep our trust properly funded, and the one thing really that we need to be doing every single year to make sure that we're continuously putting things into our trust. Now we'll talk about the secret to keeping your asset protection plan working. And you're going to see a recurring theme here. It's going to be looking out for life changes that will change how your plan works. And so if you remember, probably many of you don't, because it's a part that we gloss over, right, when we go through it, because it's the stack of documents and it's this huge process. You not only have in your plans the primary agents, trustees, healthcare agents, beneficiaries, executors, but you also plan for successors. And in the interest of not having crazy complicated estate plans that went on for all possible contingencies, we put things in like successor beneficiaries that were to my descendants, whoever they may be, in equal shares, right, for example. But as life changes happen, if a child predeceases you, if a child gets sick and the child is named as your trustee, they can't be the agent anymore. We should be updating that, not relying on the successors. We should be going in and saying, all right, I'm going to update my power of attorney. I'm going to update my healthcare proxy. I'm going to update the beneficiaries. I'm going to bump number 2 into number 1. I'm going to bump number 3 over here. We're going to tweak it to make sure that in the event that you need the documents to work for you, that they're ready to go and that we're not worried about contingencies and trying to figure out who's who. Or worse, a default. I can't tell you how many times we've seen that someone's come in with a power of attorney and both agents have passed away. And it's been 10 years and they haven't changed the power of attorney. That power of attorney is worthless. Because again, remember, it's just paper on ink. It's the planning. So things like births, deaths, someone getting sick, injured, are really important things that you need to be spotting, that even if it doesn't become changes in your plan, that we work it through your plan to say the what ifs, right? And we say, all right, so this is what's happened. How does that affect my plan? Okay. And we'll want to see that. Now, we're also going to want to know exactly who our beneficiaries and agents are. So like we talked about, our estate plan will often have contingents in there. And it's not exactly laid out. It's set up in a way that will cover all possible contingencies. But for many of you, when we sat, and I see the look in each one of your eyes when we do it, it's remote. Like, Jay, why are you making me go through this? I mean, this is never going to happen. But the thing is, statistically, it will happen, unfortunately, to some of you. Hopefully not some of you, but let's say some of the population, right? It will happen. So, a child will get sick. A child will predecease. A spouse may die before us. It happens, right? So we want to know exactly how that will work. So at any given year, we should be looking at our estate plan and preparing basically a snapshot. I would say it's our beneficiary and agent sheet, right? And saying, who are my beneficiaries under the current plan I have, and who are my agents? And that part of that process is going to be saying, are these the people that I actually want to inherit? Maybe I didn't understand that. Maybe I didn't realize it would work that way. Is this the person I really want to be making my healthcare decisions? I didn't realize it would work that way. But by doing a snapshot in time and seeing where our plans line up today versus next year, and the next year is very important. So I spoke to you about this. If we have an agent who is named in our power of attorney, who either refuses to act, cannot act, has predeceased, is sick. Let's say it's my power of attorney, for example. I have that, and I have nobody who will act under the document. Sure, I spent the time to put the thing in place. Sure, I spent the money to put the thing in place. The whole goal was to avoid the need of a guardianship proceeding. But what would happen is if we don't have an agent who will act, then what happens is we have to go through the guardianship proceeding. Now, a guardianship proceeding is a court action that we have to bring before the court to have a guardian appointed versus just appointing someone on paper. Now, that document is really a complicated proceeding. Even if it's uncontested, the court will appoint someone to represent your interests, and there'll be a court evaluator, there will be a court-appointed attorney, there'll be filing fees, process servers, court transcripts, hearing dates. We don't want to have that happen. It all could be avoided just by planning ahead. It also can be avoided by having a conversation with your family members and the people that you've chosen to be in the healthcare proxy, to be the trustee, to be the power of attorney, because this is a very important role that you've chosen them to be. What the worst thing that you can do is to take those documents, never tell them that you appointed them, and go ahead and put them into a file and never let them know that they exist until voila, the emergency comes and they're not prepared mentally or physically to deal with the task at hand. I'll give you another example of another estate plan that how things can go wrong. So Heath Ledger, if you remember, Heath Ledger is an actor. He was Joker in one of the recent Batmans, probably about going back probably about 10 years at this point, but it seems like yesterday. In Heath Ledger had a will. Okay, so he had a will. He went ahead and prepared a will prior to having a child, okay? And this might apply to you prior to having a grandchild, for example, leaving everything to his parents and his sisters. After that, he had a daughter named Matilda, and he never updated his estate plan. Now, he passed away, unfortunately, from a drug overdose, and his will left everything to his parents and to his sisters. Now, what happens to Matilda? There was a lawsuit, a settlement outside of the media. We don't know exactly what's happened, but really what we do know, what we can take away from it is the father assures that Matilda, quote unquote, will be taken care of. I don't think any of us want to leave our estates up to that type of chance. Had he reviewed the estate plans and made a simple update to the will, okay, he would have been able to leave everything to his daughter, as I'm sure that he intended to do. But I think he was 27 when he passed away. I don't think anybody was thinking that, today is going to be the day. There's a song that goes, everybody wants to go to heaven, right? But nobody wants to go today, right? We're not ready to go. We always think there's going to be a tomorrow, but this was not obviously the chance for him. And so what happens is he left that to chance. Now, I truly hope that Matilda has been, quote unquote, taken care of, but the father has no legal obligation to do that because he was a beneficiary of the plan. His sisters were a beneficiary of the plan. Matilda got nothing legally under the estate plan. So what do you need to be doing then? So what you need to be doing each year is reviewing the plan every single time there is a life change. If you have a grandchild, if a son or daughter gets sick or ill, if you've spoken to a son or daughter and you know what, they just are not going to be able to be the healthcare agent like we thought because they told me, I can't make that decision for you, Mom. I can't pull the plugs pursuant to your living will, right? You had that conversation at Thanksgiving. We need to be looking at the plan every year, okay, to be saying, do we have the appropriate party's name to be able to help us? Do we have the right beneficiary's name to be able to help us? We need to figure out what that means for your wishes. If your wishes about, for example, healthcare are to have a strong advocate, someone who will fight for your desire to have holistic medicine applied, for example, right? That is your wishes. You need to make sure the person that you have selected as your healthcare agent will actually fight to make sure that happens. You have to make sure that if you intended to have a gift for your grandchild, that we're not making that to be unknown. We're not making that to be like, you know what, my son will take care of it. No, we want to make sure that we put that into the document. It doesn't need to be complicated once we have the basic structure in place. It's just a part of this ongoing process. The appropriate changes that you need to make to keep your wishes in place is that updating the documents and updating your plan, whether that be titling assets into the trust or changing trustees or healthcare agents to match what your goals and objectives for that given year are, all right, in terms of who gets to make the changes and who is going to be the beneficiaries of your plan. All right, so the third topic now that we'll talk about is going to be changing Medicaid and tax law changes. And this is a really difficult one, right? So many of you have goals to be able to minimize estate taxes, minimize income taxes that will be due upon your deaths, and also protect your assets for Medicaid. Now, just a reminder, Medicaid is this program that covers long-term care. Long-term care, and I hope none of you need it, but statistically, there's about a third of the population that does need this, and that's home health aides and nursing homes. And they are very costly. Right now, they run about $2,000 to $8,000 per month for a home health aide, depending on how many hours you need. Obviously, if you need a live-in, it's going to be much, much more. And if you need to be in a nursing home, the nursing home runs about $15,000 per month. Now, the Medicaid program is what pays for that for many people. The idea being, though, where we've had helped you with the value add that we have done is to be able to plan ahead so that way we can qualify for that care, have that care provided for by the state, but not have to spend down all of our money, protect our home, protect our nest egg, protect our IRAs, right? Do whatever we need to do to be able to protect as much as we can. Now, the laws change though. So a reminder, especially when it comes to legal changes, your plan that we gave you was based on the laws in effect at that time. Okay, and the laws are constantly changing, and it'd be you know, it's very difficult. You'd have to be reading every single law journal article and every single one of those stimulus bills that we talked about, where they bury in all this information to find out exactly right what the law changes have been. But remember, the law is what it was at the time, and your will gets and your trust gets, you know, put in place as a snapshot based on that. So that's important to make sure that the will that you have in place still matches the objectives and the needs of the laws that are in place today, right? And so sometimes that makes no changes to the will after you look at that, no changes to the trust after you take a look at that, because there haven't been any significant changes. But sometimes it's like this year where there's been significant changes in the community Medicaid program and in the tax laws, and we'll talk about that. So these changes, though, have a very, very important change on how much of your money can be protected. For example, there's going to be income taxes due when you pass away, making sure that we preserve step-up and basis, right? So we can pass as much of our income tax along to future generations as we can. Make a big difference. If we don't take advantage of those changes, then we are leaving money on the table that we could have otherwise protected for our family. Other things become kind of proactive and rather than reactive. And we'll talk about some of the changes in the Secure Act and how those have created opportunities for people who have larger IRAs. I'd say IRAs of $750,000 or more. So if that applies to you, I'd be glad to have a separate conversation just on those options that you have there. But if you have $750,000 or more in an IRA, sometimes it might make sense to take a tax hit now against rising income taxes, which are going to go up in the future, because IRAs don't get what's called a step up in basis, and our kids will have to pay taxes on that. And there's been significant changes in how quickly our kids will have to take money out of the IRA, which will most likely bump them into the top tax bracket as they withdraw money out of those IRAs, which means effectively your IRAs could be being taxed at 37% in the future on their income, right? So we want to think strategically and multi-generationally. So that really creates opportunity for many of you to think about that you can actually be proactive and taking opportunities that present themselves by legal changes. So let's talk about a specific one right here, right? So there is a new community look back for Medicaid. So this was the topic that I told you we would be really talking about today as a hey, you got to watch out for this. Now, when many of you came in, what happened was the way that community Medicaid worked was that there was no look back period. And just a reminder, what was community Medicaid? Community Medicaid was this program that paid for home health aides. I think for many of you, we said, let's do Medicaid planning. Oh, I never want to be in a nursing home. Well, it could happen. Great, Jay, let's put it in a trust. But what about community Medicaid? What if I just put my house in a trust now? I keep the rest of my assets outside. What about community Medicaid, Jay? And I said to you, there's no look back for community Medicaid. So actually, if you needed care for a community Medicaid and you need a home health aide and you wanted someone to come into the house, you could go ahead and do the planning the month before you needed Medicaid to cover. So I could have, let's just make it up, between all my assets, $1 million in my name today. And on July 1st, as long as I did a plan this month, I could be eligible for community Medicaid. The state did not look back to see what I did the month prior, the 5 years prior, the 3 years prior. They didn't care. Now, in nursing home, they had this 5-year look back period, right? This 5-year look back period was where we have, all right, so I can't do this planning at the time. We need to do this planning at least 5 years prior. They're going to look at what I did during the previous 5 years. If I've gifted money to a trust, for example, as part of our asset protection plan, then that money will have to be contributed towards my care. I will be penalized. So the New York Medicaid redesign team got together and said, we want to apply something similar to the nursing home look back period to community Medicaid. And that's what they did. Now, this again, it doesn't make, you know, headlines. This is not, you know, juicy topic to talk about, especially everything that's going on in the world. Where they bury this stuff is this gets buried in the budget documents. So every year, the New York State government, even the federal government, they do the same thing. They pass a budget. You might say, what do legal changes have to do with the budget? Doesn't the budget just have to do with spending? But it's politics, right? So what they do is they use the budget that needs to get passed as the leverage. They say, well, we're not going to pass the budget. We're not going to vote for it. We're going to let the government shut down. If you remember a few years back, we had a number of shutdowns constantly going on. They're going to let the government shut down unless you work this into the bill. They put together what they call omnibus bills. They're huge bills, and they dump in all the changes that the political parties want to accomplish, and they get it. Most of the laws that get passed every single year get done in the budgets, and they're passed there. So the New York Medicaid redesign team went ahead and forced through this community look-back period. So starting October 1st, 2020, okay, starting October 1st, 2020, there will be a 2.5-year look-back. So that's a 30-month look-back. So just like nursing home now, we have to be planning a little bit more proactively. Maybe we're putting assets into a trust a little bit sooner. Maybe we're looking at that opportunity to get those assets into a trust now because we want to get in ahead. Now, we'll talk about some of the unknowns that we don't know, is that we don't know exactly how this phase-in is going to work. Again, it's an inefficiency in the way that laws are passed. What happens is the government, the legislature, the Senate, right, they pass a law and they pass it off to a government agency that will then administer it. So if you remember the Paycheck Protection Program, right, that has been passed by the Senate, the Congress, the president, and they give it over to the SBA, the Small Business Association and administration rather. And what they do is they figure out how to actually implement the law that the politicians wrote. And the same thing happens on the state level. And what they do is they had passed this law and pass it over to the Department of Health and the Department of Social Services to draft and craft regulations for actually how this will work. Now, there's really two alternatives that I can see as being options that happen. One, anybody who makes, actually, I should say three options that could happen. And I don't know which one will happen. But one, it could be anybody who made gifts before October 1st, 2020 will be grandfathered in. And they'll be under the old look-back period. So no look-back period. So that means if that's the case, we should be putting assets into a trust now. If instead, the other option that might happen is that the state might say, we're going to make it so anybody who applies for care before October 1st, 2020 is grandfathered in. So not the effective date of the transfer, but when you applied. And that might be the way that the state goes. The third thing that might happen, and sorry, go back to that topic, that means if somebody's thinking about applying for community Medicaid, the care level need is there. It might be needed in 6 months from now. It might be needed in a year. Maybe we should look at applying now to get ahead. And those are two great options that you might have as opportunities now if those fit you. If you think you have been waiting to get assets into a trust, or you might need care in the somewhat future, you're going to get that in place now. It doesn't mean you need to use the home health aides. It might mean we just apply to get coverage. Now, the third option that might happen, and probably the most likely, but we don't know, so we're going to keep an eye on that, is that what will happen is anybody who applies after October 1st, 2020, and anybody that was on prior to could also have to, when they recertify, have this look-back issue and have a look-back applied. And now, I don't know if that's the one that'll happen. We just don't know. Those are really the three things that I can see happening. But what's going to happen is we're going to be continuously monitoring the situation because the Department of Health is going to need to be able to issue regulations for how this program is going to work to the local Department of Social Services. And that'll probably be done at some point this summer. I think they've been a little bit preoccupied with coronavirus and COVID and everything that's been going on, but they do need to get that in place and give us some guidance. But if we want to be proactive, again, if we've been waiting on funding the trust, then let's put some assets into the trust. Maybe we shift a little bit more. Remember, a lot of us sat and we said it wasn't all or nothing. We said we were going to say, well, we want to put some assets in now, some assets in later. Maybe now is another time to come up with a funding strategy. Sit down and look at the assets and how much you want to put in. The other piece is if you think that you might need care in the near future, it might be best to go ahead and apply now, even though you don't need to have the home health aides in place today. So let's talk about then, my slides will advance for you. I'm just going to take a little bit of liquid refreshment because I am parched. So what you need to be doing then each year with your estate plan is to stay educated on recent developments in the law that will impact your legacy. Okay, so this is really important. So you need to stay educated on this. You're all somewhat educated on the topic because I've helped you, but you also came in educated. You knew what a will is, you knew what a trust is, you knew basics about your options, but we need to be able to keep on top of these changes. So you need to be looking at those every year. And a great place to be looking would be those budget bills if you would like to look there. It doesn't always often make it into the press release of the bill. I often find myself pouring through line by line, but that's where we'll often see them. Then the second key is to review the plan to make sure that with the new law that has been enacted, that your plan, whether that be the actual documents, but also our funding plan, our agents plan, our beneficiary plans, right, that they are all going to accomplish the same goal. So for that client example, where someone has been waiting to put money into a trust because they thought I have no look back period, and chances are I'll need a home health aide and then I could do that for 5 years. At that time, I'll put the money into a trust, and the rest of my money rather, and then I'll get the nursing home look back period. We're not going to be able to do that. That would be an outdated strategy. And that comes from that planning, just like a financial planner, where you go in and you look at market changes, you look at your needs in the next 12 to 18 months out, right? Proactively planning and making educated decisions today about what your needs for the future are. And then that also gives you the opportunity to take advantage of unique opportunities that follow shortly after changes. So changes are like breeding grounds for opportunity for you, right? And if you have somebody on your team that is looking out for those changes and how those opportunities can help people, like the IRA, for example, that we talked about, this concept, which I wouldn't think about until you really dig in and run the numbers of liquidating an IRA, paying the tax now so our kids don't have to pay 37% in taxes when they are forced to withdraw it in 10 years. So that is one of the other law changes I wanted to touch base with you on today about. It's the Secure Act and how that impacts your IRAs. And just to boil it down real simple, under the old law, your beneficiaries would be able to inherit your IRAs. They don't get what's called a step up in basis, meaning they still have to take and pay taxes on that IRA, but they don't pay it when they inherit it. They pay it when they withdraw it from the account. Now, some people just withdraw it all, but that doesn't make any sense because it's taxable income. That's money you have to pay taxes on. The law actually provided that your beneficiaries could inherit it and then stretched payments out over their lifetime. And where does that come from? Well, on the one hand, if I take it out, I have to pay taxes on it. So the alternative then is, right, the complete other end of the spectrum is you say, Jay, what if I don't take it out? I have other assets. I'll let that grow. I'll let that be let it grow tax-free. I'll let that be some money for my grandkids, right? The IRS doesn't let you do that. They would force you to take it out over the person's lifetime. Now, under the old law, you'd be able to stretch that out over the person's lifetime. What that meant was if, let's say, your 55-year-old child, right, or your 45-year-old child inherited it, and they have a life expectancy of 35 years, they would be able to take out the full balance of the IRA in 35 installments, right? So that minimizes the amount that they take out per year, meaning they pay less in taxes and allow more money to continue to grow tax-free in the IRA. But under the new law, the Secure Act, what happens now? What happens now is that the beneficiary is forced to take out that IRA in 10 years. What that means is, let's say you had that $1 million IRA. If you have a $1 million IRA, your beneficiary is forced to take out, or your beneficiaries are forced to take out all of it in 10 years, which means that they'll have to take out, not accounting for the growth of the IRA, but $100,000 per year. Now, if I'm already making, as a family married couple, $150,000, add another $100,000 on top of that, that's going to put me into the highest tax brackets. Now, that's also going to happen because the tax brackets are going to go up in the future because they'll automatically bump back up to their pre-Tax Cut and Jobs Acts. So these are things that we're thinking about, that where we have changes, it creates unique opportunities to strategically look at the numbers and say, well, is it actually better to liquidate the IRA, all of it or a portion of it now, and find another way to leave a true tax-free benefit to our beneficiaries, where they won't be forced to pay 37% in taxes on it. Now, if we're in that 37% taxes on $1 million, that's $370,000, right? So that's a lot of money. And so we're not talking about pennies here. And you might think, well, that's my kids, right? But we're not doing that. We've been, with the plan that we've helped you put in place, is to think about things in a generational wealth protection plan. So I want to protect as much for my family and give them as much as I possibly can. So just to recap what we've covered so far today, we have talked about how you can keep your trust properly funded. You will avoid probate and maximize asset protection. Just a reminder, the trust that I've prepared for you will only take care of what is actually inside of the trust. If we didn't prepare a trust for you, decided not to do that, you used a will needs to go through probate. Probate is that court process where we have to have a judge give our executor permission to get access to our assets. That can be time consuming and costly. Now, I think right now is a perfect example. For 3 months, the courts were closed and no one could get access to their assets. And even predating that, I still have a client that is 3 years waiting for letters of administration from the surrogates court to be able to sell a condo, right? So these are things that we don't need to do when we have a trust. But again, the trust is just a piece of paper. It's the planning. So if the assets are not in the trust, then they don't avoid probate. Also, if the assets are in the trust or we don't gift them to the trust as part of a planning strategy to increase our asset protection goals, then they'll be part of the Medicaid clawback. They'll be part of the taxes clawback. Maybe they'll be increased income taxes that we have to pay on them. We also discussed how by reviewing your agents and beneficiaries frequently, you will ensure that your wishes are respected and that you can avoid costly court proceedings such as guardianship actions. And so this comes to making sure that those life changes that happen, that you review the plan to make sure your agents match what you want and your beneficiaries match what you want. Because if you don't, let's say we have a default now. We have there's no agent who can act for me. Why? Because I only named one. I didn't want to name somebody as my successor. Or I named someone, I didn't name a successor. What happens if the person refuses to act or can't act or won't act? What happens is we have to go that guardianship route. And that's going to be basically the rest of your lifetime having your agent, who is now called a guardian, having to be part of this court proceeding. That they're going to have to go through hearings and file accountings and ask the court for permission for everything. So it's something that you want to avoid, and you can do that by just looking at it, just looking at the plan to make sure that it works for what the current circumstances are. We also talked about how you can keep your plan up to date with legal changes to make sure that your plan remains adequate to accomplish your goals. So we talked about some major legal changes that have happened since December 2019 coming up till today, and there are going to be more in the future. Not only do they erode how well your plans will work for you, they also create unique opportunities that you could be proactive about taking advantage of to protect as much for your family as possible. So if there's one thing that I hope that you get from today's webinar, is that by remaining proactive, you can protect your family and leave the legacy you desire. Now, you were proactive, right, when you came to our office to prepare an estate plan, but that shouldn't be the end. It shouldn't be a checklist. And what I hope that I have provided for you in today's webinar, and I'm going to stick around after we're done with today's webinar to answer as many questions as I can for you, is you have a template, a checklist that you can do each year. It's going to be able to be providing an asset sheet, all right? So preparing an asset sheet every single year so you can see exactly what your assets are worth and how they're titled. That'll give you a benefit to your trustees, your executors, your agents, the ability to know where your assets are, how much they are. It'll also help you catch what things aren't in the trust that, you know what, I have everything but $15,000 in the trust. What happens then? It'll have to go through probate. It will prevent that. Now, you have a couple options in doing that. What I would recommend that you do is maybe it's around tax time, wherever you think it's a good time, the end of the year, whatever works for you. You set aside a day, mark it off on your calendar as estate plan review day, right? And do this yourself. You can go down the list. You have everything that you need to be able to say, look, here's what I need to do. I want to make sure that I'm going to compile this list. I'm going to go ahead and put it inside my estate plan sheet. We are good for the year. I did that towards the end of the year. Your other option is, if this is something that you think is very important for you, is something that we can help you with. So how do we make that happen?